All right, so as you saw, the format was already in the first part of the Stakeholder Plenary interspersing discussants and comments from the room. This second part is entirely about your comments. So there's no predetermined speakers. The objective is to continue this discussion on the state of jurisdiction on the internet, the cost of inaction or the cost of uncoordinated action, but also to give elements of concreteness to this debate, and maybe also to pick on things that have been said in the first part. So I already had two speakers at least who were registered. Andrew is there. And I think there was somebody else who wanted to speak already. Okay, Peter Van Rost. And I would like to also suggest contribution. I like very much the comment that Stefan van Gelder was making earlier about the story about tobacco company advertisement on cars, because it's a perfect example of very, very concrete issues that you may be confronted with. So if you want to share to the group things that are connected to your own experience, not necessarily elaborating very long, but just mentioning concrete cases so that we have a sort of tangible feeling on the problems that you're confronted with on a daily basis. The other thing is, I was struck by the comment that Chris Painter made on sovereignty is not absolute. I think the question of the responsible exercise of sovereignty is very important. Thomas Fitchen as well was reaffirming the validity of sovereignty and the validity of national laws. And once again, what I wanted to highlight is that this is not about having to choose one or the other. This is not a zero-sum game. And basically, the challenge is precisely to reconcile the respect of national laws and the cross-border nature of the internet. So, without further ado, I just want to open the discussion. Same rule as before. You raise your hand. The mic will come to you. But keep in mind those few questions. And please pick anything that you've heard in the first presentation, be it innovation, be that legal interoperability, any concept or things that you want to react upon, and feel free to intervene. Andrew, there's a mic there. And the clock is still at 3 minutes.
Thank you. My name is Andrew Bridges. I'm a lawyer at Fenwick & West, a law firm headquartered in Silicon Valley. And I'm a litigator, but because of my litigation activities, I also advise companies on business plans and the risks of business plans. My firm represents some of the largest and best known internet and technology companies, but my particular focus at events like this comes from the fact that we also found companies. We start companies. We start one-person, two-person operations and work with a lot of small and medium enterprises. And one concern in advising them about the risks of their business models is, of course, the diffusion of different rules that apply in different jurisdictions. That's what we're here to debate. One fear is that the need to advise them because of the multiplicity of rules, one needs to advise them usually towards the strictest standard. And so if everything's going to harmonize around the world, it's going to harmonize around the least productive, least innovative rules. And an alternative to that is to have some voluntary systems that might somehow reside apart from the legal rules. And on this point, I'd like to echo the comment of Juan Carlos from Derechos Digitales, that the voluntary systems are often outside the rule of law. And I have seen advising some clients, particularly intermediary company clients, small clients, that The rules they are being asked to conform to don't provide due process. They flow from allegations and unproved accusations. And sometimes there's believed to be strength in numbers. One case recently, they say, well, 18 million complaints mean there must be something wrong there. The fact is, it could be 18 million false accusations, and just multiplying false accusations doesn't make anything true. So this is a very difficult challenge. I'd like to respond to one other comment about the large companies. I think it's a mistake to confuse centralization of the internet with economic market power. They aren't necessarily the same things. And one thing I've observed, particularly in a lot of the recent debates about European rules applying to American companies, is that a lot of rules seem to be fashioned to go after Google and Facebook. And the net is that these rules will make it impossible for small and medium-sized enterprises to develop. Because if these rules apply to the biggest companies, only the biggest companies will be able to cope with the regulation. And the net effect of these rules aimed at the largest companies will be to give the largest companies more power while preventing new companies from even coming into existence. Thank you very much.
Yes.
Good afternoon, everyone. My name is Peter van Rost. I'm the General Manager of Centre, and Centre is the organization of mainly European CCTLDs. I'm not surprised to see quite a few of my members here in this room, because this topic has been discussed for, well, at least the last decade that I'm aware of. And this is why we're here as well, to listen to practical solutions to some of the problems that some of you might already have encountered, and to share plenty of experience and plenty of concrete ideas and suggestions. Secondly, there are three reasons why we're here. The second one is that for those of you who are following the debates in Brussels, this is the time of the reports by the rapporteurs from the European Parliament on the single digital market. By the end of tomorrow, the rapporteur on consumer protection in particular is looking forward for solutions of some of the cross-border jurisdictional issues that they are facing in the current draft. The consumer protection regulation touches upon each of the three streams of this conference. So it's very timely, even though a couple of days earlier would have been great, so that we could have fed it into that debate as well. The third reason why the CCTLDs are here is that we are constantly reminded of the need to provide training. And I hope it's part of the discussion that we'll have as well, on how this group not only has a duty to solve an issue, which might be a bit out of reach, but there is something we can all do. We understand how these things work, and we should educate everybody who should need to know. There are a couple of examples, and I'm adding here to Bertrand's question for specific issues to solve. They're not necessarily jurisdictional related, but they are at the heart of the problem. Even in this conference, we see plenty of assumptions that taking down, seizing a domain name equals removing the content, which obviously, as we all know, is not the case. But that is a fundamental problem still today with, in particular, regional regulatory efforts. A second very concrete example is when talking about the domain name, not everybody seems to know what that really means. So a practical problem that plenty of my members get confronted with is that on a CCTLD level, they're requested to take down www.example.eu, which obviously they can't without taking down example.eu. And it is always a very long journey to explain that. So basic training is probably of essence, and I hope that we can contribute to this conference in this way. Thank you.
Thank you. I have Elizabeth Finberg, then Carl Bildt, then you, and you. No?
Hi, my name is, is it on? Hi, Elizabeth Finberg. I'm the General Counsel of Public Interest Registry, and we manage the .org top-level domain, as well as .ngo and some IDNs. Getting back to the question, central question from last session, why am I here? I'm here representing, in part, DNS service providers, domain name system service providers, and I think, like others in this room who are DNS service providers, there's a growing concern about unrelenting pressure to take down content. Without court orders, without due process. And I think, a fundamental question that we should all ask ourselves in this room is, do we want to solve the problem of global jurisdiction and hate speech and all of the things that we're going to talk about today? Do we want to solve that by simply going to the entities that have the technical capacity to disable content, to take down domain names, but not necessarily the legal authority or the moral authority to do so? And I think it's just a really fundamental question, because of course, if you can just go to the service provider and say, take down this name, because I'm telling you to, because trust me, that's a much quicker, easier solution. It's also a very slippery slope. So that's why I'm here. Look forward to discussing it, and looking forward to a great conference. Thanks.
No, wait a minute. I had this. Go ahead.
I wasn't intending to say something, but I will do it anyhow. I'm worried by some of the things that, going to the previous speech, some of the tendencies that are there in the public debate. Particularly this taking down content thing, which has become very, very popular and is, in my opinion, very, very dangerous. It has become popular for partly the wrong reasons, in my opinion. People do believe that radicalization on the net is one of the chief causes of terrorism. It's not. I would argue that the by far most dangerous medium when it comes to radicalization is television. I mean, if you take sort of direct broadcast satellite television that is beamed towards certain countries from certain other countries, that's where we have the problem. And you can't take down that, obviously. But then it has become very popular to take down content on the net. And if we go down that slippery slope, first, we won't serve the purpose that we want. Secondly, we will, of course, play into the hands of those that have slightly different agendas from ours. And here I think, to go to what was said previously, I think you all representing the different communities, be that the legal or the judiciary or whatever, expert communities, because that's you, have enormous task in public adult education in terms of educating policymakers. And this interface, I would say the lacking interface between what we call the expert community on these issues and the policy communities of different sorts, is becoming an increasing problem. And that's why when I talked initially, I said, when addressing these issues, I would like to stress a step-by-step approach. If we say we're going to have a big solution to these particular issues now and give that message to policymakers, I'm quite certain that solution is going to be the wrong one. Might even, as a matter of fact, be a dangerous one. We need to take it step by step, discussing carefully, inform the policy communities of all of the technical, legal, and other issues that are there in a very complex world in order to get these things right. Because if we get them wrong, it's not that it will be a minor error, it's got to be a very major problem indeed. And this taking down content, slight hysteria that we have at the moment in some of the public discourses, I think France is not excluded from it entirely, to put it in those terms, is dangerous.
If I may just piggyback 1 second on what you said, I hear a sort of echo from what was said before, and it relates to speed. The fact is that the number of people who are dealing with policy that are becoming de facto interested in internet matters is growing faster than our capacity to educate, isn't it? So that was not a question, it was more, unfortunately, there is the mic. I keep this one, I mean, it's mine.
Good afternoon, everyone. I'm Jane Hill. I'm a data privacy lawyer from London. I work for British Telecom. I'd like to say that the issues being discussed are issues that we deal with every single day of our working lives. So I'm very, very pleased to be here. I want to make a couple of points. The first one was to respond to Andrew's comments about how new laws are being made, really directed at the Googles and Facebooks of this world. And I'd like to make the point that those laws that are being made are actually to protect the fundamental rights of citizens. And there's no reason why new products and services can't be designed with privacy in mind. And that's the same whether you're a big company or a medium company, whatever. It makes good business sense to have data privacy rules built into your products and services. The other point I'd also like to make is around the whole blocking piece. Anything in that space. We've seen recently a very active judiciary in London that's extended blocking orders, not just for copyright infringement online, but now out into trademark. So good sort of websites sort of selling goods and services in breach of trademarks. So we are seeing quite an extension of that as well. Anyway, those are a couple of points I wanted to make. Thank you.
Thank you. Yanis?
Good afternoon. My name is Jānis Karkliņš. I'm ambassador of Latvia at the United Nations in Geneva. I most probably need to say that I will not speak for my government because I don't think that my government would accept what I will say now. There was David Sutter's comments that triggered this desire to say. All of us here in the room, we have been educated on the Westphalian, based on Westphalian system. And this is the way how we think, this is the way how we perceive the world. Internet is slightly different, and it does not recognize one fundamental element of Westphalian system, and that is borders. Nevertheless, we apply our knowledge to this new system, and we're trying to squeeze it in our perception of the world and our knowledge about the world. And I think that this is where we're actually permanently failing. We need to try to sort of step out of our Westphalian thinking and to do creative thinking, and but before that we need to understand the complexity of the problems. So that's point number one. Point number two is that we have custom to take time when we're making policy. And internet is developing, at least in past 20 years, much faster than we're used to make necessary decisions. So, and that is another problem. We do not know which kid in which garage is working on something which will be next big thing, which will again put upside down all our sort of understanding about this world, and which will become something major. And we're permanently struggling with that. And so whether there is a solution, I do not know. And that's why this conversation is important and also fascinating at the same time.
Thank you. My name is Peter Swire. I'm a professor at Georgia Tech in the United States in law and ethics, and also an appointment in computing, College of Computing. I'm going to be working on the mutual legal assistance part. And in explaining this issue, which was very obscure for many people until recently, I think I can explain in 2 points why it seems more important today. So the first thing, which I think many people see, is that there's globalization of evidence. Many times the evidence for a crime, a typical crime, is held overseas. The second part's not as obvious, which is many communications that police care about today are encrypted in transit. So if you do your email from your home, if you do text from your phone, the wiretap does not work locally. The police can get a wiretap, but they can't read the communication. So we went from a world where the police had the evidence inside the jurisdiction and a wiretap inside the jurisdiction to a world in which the police do not have the evidence in the jurisdiction and cannot do a wiretap. And so the frustration for the police is very great in many, many ordinary cases in a way that wasn't true before. And so I think these factual changes around technology are pushing into a much harder set of issues around mutual legal assurance than people understood before. The second point, and I'll make it briefly, Paul Nemetz, I think, has left. He's a wonderful lawyer. He spoke in favor of democracy. I am also in favor of democracy. However, in many of these issues about take down content or keep up content, prevent use of data or use it for analysis, we have democracies that differ. And saying the idea of democracy doesn't resolve the issue. In many instances, we have different democracies choosing different rules. And so simply saying democracy should win doesn't turn out to solve the problem many times. Thank you.
Hi, Hi, my name is Michelle Paulson. I'm the Interim General Counsel at the Wikimedia Foundation, the nonprofit that runs Wikipedia, as well as a number of other online collaborative educational projects. The mission of the Wikimedia Foundation is to bring, basically to collect and disseminate freely the sum of all human knowledge. And we mean all of it, and it should be to everyone, no matter where you're located, what language you speak, what lifestyles you believe in, what beliefs you hold. And one of the things that has become increasingly problematic and has always been an issue on Wikipedia as well as in the real world is what happens when people with different systems of belief and values have to come together to agree on content. In Wikipedia, it's done through talk and consensus. And this is a model that I would like to see in any future framework in a multilateral situation. But one of the reasons why we're here today is because what becomes problematic when you start talking about all of these different values, some of which are conflicting, some of which have different priorities. As Andrew said, you start becoming basically the lowest common denominator, and that really negatively impacts the ability to access and share knowledge, which in turn impacts our mission, and really what I think should be the mission of every human should be able to fully educate themselves and explore and read and find out the world around them. So also, I echo a lot of what Andrew's points were before, in that when you start trying to develop regulation that will govern the world, you start seeing pretty onerous requirements on companies and organizations, nonprofits, and individuals. And because the internet has been the single greatest force in equalizing force in the world, I'm afraid that when you start putting relatively high regulations on people and organizations alike, you start to freeze what the internet is to what it is today. And I'd never want us to be in the position where we look at the internet of 2000 to 2016 and start referring to them as the glory days of the internet. I think our best days should always be forward.
Michelle, just one thing. As a note, I think Wikimedia is a perfect illustration of what I was mentioning earlier, of the fact that there are several governance systems or frameworks, and that actually the way you organize the management of the content is by your own community, and this community on a topic-by-topic basis, on a language-by-language basis, has to cope with the national laws. And one of the interesting things when we had the meeting that we organized earlier in September in Paris is the sense that there's a higher level of granularity because each sub-editor or subgroup is able to potentially tweak the content so that it is acceptable but still relevant and still faithful, whereas most of the discussions we have regarding content are black and white, on, off, take down, or keep on. Just wanted to highlight this because the model, and you probably will have the opportunity to talk again. tomorrow. This is a very interesting model where it's the community itself in the site that is actually managing those key questions. And apparently they managed to find solutions. Please.
Hi, my name is Chris Riley. I run global public policy for Mozilla. We are a bit of a strange organization, I would say, in this space. We are a nonprofit, mission-driven technology company with products that are used by hundreds of millions of users around the world. And we are also a global community of users and contributors. So our mission and the angle that we bring to this conversation is that internet users need to have a voice in shaping the internet and shaping their experiences. We incorporate that into the products that we build. We incorporate that when we work with policymakers at the national level. And I continue to look for ways in international contexts and settings like this that we can do the same thing. So back to the question in hand, the issues in the global internet jurisdiction space. This is incredibly broad. Right? It is incredibly difficult to try to get your head wrapped around everything that is on the table over the next few days. So I deeply believe we will make the most progress if we can continue to subdivide, bring more of an engineering mindset to this. Let's find the most specific problems we can, and let's try to build a toolkit of solutions, of processes, of mechanisms, so that we can cover more of the space and really understand how we can make concrete impact. And in doing that, I want to encourage everyone here to think about how we can bring the voice of the internet user into these processes, solutions, and mechanisms. I know that's an incredibly difficult thing to do. It gets right into the middle of the tricky balancing of inclusivity and decisiveness in structures like this. But this is, to me, the root of the trust gap that has been raised earlier in these conversations. And unless we can make them really effective and inclusive of internet user voices in a meaningful yet scalable and sustainable way, we won't address the underlying problems here.
Good morning. My name is Gemma Campillos. I work for the Ministry of Energy, Tourism and Digital Agenda in Spain. It's been renamed just last week. And I'm going to make things even broader, but it's important that we take into account the whole picture when we talked about international cooperation in these issues. I work for one of the ministries that deals with consumer protection in Spain, in this case in the internet ecosystem. In Spain, and I think in other countries like France, many of the market oversight tasks are entrusted to ministries, to administrative bodies, and they don't count on the help of the police or on courts to enforce laws. But even though they face on a daily basis issues that are connects with the whole world. We address requests to intermediaries, and most of the times they don't even answer our letters. And when they answer, many times they say that they need a court order. They think this is due process, but in Spain this is due process too, that we need to address these requests. We are entitled by the law to do so, but even though they don't recognize us as legitimate authorities. Maybe these are not criminal issues, not are urgent or are as pressing others, but they need to be taken into account because consumers often trust administrative authorities and don't go to courts to deal with petty frauds that they are victims in their internet. Thank you very much.
Please.
Well, thank you very much. My name is Pia Rantala-Engberg. I come from Finland. I'm the cyber ambassador at the Finnish Ministry of Foreign Affairs. And I'm following, of course, the whole cyber agenda from a foreign and security policy perspective. What I wanted actually to underline, I very much, of course, agree with Carl Bildt, who just left, was saying that it's important that policy people and experts like this room here are really, finding each other. That is, of course, a crucial issue. we policy people are really lacking behind. And needless to say, this audience really is, of course, aware of the issue. What we need to do, I think we really have to build the trust. And in order to build the trust, we need this constant dialogue. And why I wanted to take the floor is also that I want to be an optimist. I mean, we see here that there are a lot of issues we have to tackle, a lot of problems also, or legal issues. We don't find the easy answers today. But in order to build the trust, we need the interstate dialogue. We have to, but we also have to have this multi-stake audience on board. We can't, if we want to understand the future, we have to have the academia with us. We have to have the private companies with us. And also, having said this, I still think that we shouldn't be that pessimistic. There are really already very good things done and good processes ongoing. If we think about international law and norms work, so we have the UN GIJC, group of government experts, working already many years on the issues of trying to find how the answers to the questions, how to apply, how the international law and norms apply in the cyber space. And already by now there are, I mean, countries, 20 to 25 countries who have been sitting in these groups representing really different interests, really different views what comes to state control of the net, of the contents, and so forth. And still those countries have been able to define and come to a conclusion where they have found common nominators. And this, I think this work is really a good basis. And I think there is an interest among states to find the answers, but the thing is that we just need to have and give some patience. I mean, so we have to be patient. We have to give a bit of time for ourselves, even though we know that we should be more quicker, we should be more efficient. But these are processes, and I think also with this one we need to just be a bit realistic but at the same time still not to give up. Thank you.
Still Chris Painter. I wanted to actually key off of some of Peter's comments and some of Pia's comments as well. I think, and I want to thank you guys for putting this group together, and I've participated in some of the meetings over the years. I think one key thing about this is bringing these different stakeholders together and not taking absolutist views. I think that people represent different communities and often don't even see or interact with people in the other communities, and that is a real problem. I think even today we've heard some very absolutist views, and unfortunately sometimes people give an absolutist view and then they leave and they don't actually talk to the other people who have different views, and that's a problem. And I think, you know, having seen different sides of this, I think everyone should understand that law enforcement has a role to play in getting electronic evidence and being able to protect the public, and that is not antithetically an opposite to protecting privacy and civil liberties. In fact, if you're doing that well, you can protect more privacy, you can keep the breaches from happening. And so you really have to look at both sides of the puzzle and not simply say, as Peter mentioned, we're in service of democracy. We're in service of democracy in everything we do. We should be, at least, you know, at the people around this room. So I think that's very important, to make sure you're bringing those communities together. We've done a better job of that in the US than we used to do. We have brought people from the security community, the economic community, the human rights community more together to have these conversations, and I think that's important. The second thing I wanted to mention is, as people go into the working sessions tomorrow, to think about concrete things we can move forward. We're not going to solve the whole issue at once, but look at some of the pieces we can pull off. And I read all three of these setup papers, and one thing that was mentioned in every one of them was this idea of terminology and having a template or a requesting form. We've done this. We've done this multiple times. I used to chair a then G8 high-tech crime group where we did a template. Interpol's done a template. Templates are worthless if people don't actually use them. And so getting widespread use of them will help, not solve, but help a lot of these issues. So let's take some of the things we've done and make sure they're operationalized.
So what you basically say is, it's not the concept, it's the commitment.
Well, it's a commitment, it's the follow through, and it's actually trying to take advantage of some of the things, the good work that's been done, and just make sure that's more spread around. I've had, in my diplomatic role, conversations with other countries where a lot, not all, but a lot would be solved if they gave the right data in the first place, and we can follow up on it. It doesn't cure everything, but it cures a lot of it, or there's better training. So there are piece parts of this we can break off.
Absolutely. Who was next? Greg Nojam. You're on, Nina. You're on the list.
Hi, I'm Greg Nojam. I'm with the Center for Democracy and Technology in Washington, D.C. We recently experienced an earthquake, not a physical one. I want to just share with you a struggle that I've been having as I've listened to the comments so far. And here's my struggle. I have a strong interest and preference for clear rules, for rules that respect sovereign interests. And yet, at the same time, my organization and really a lot of my life's work has been dedicated to the protection of privacy and free speech. And I want the outcomes to serve those interests of privacy and free speech more than I do to serve things like efficiency and clarity. If a rule is very clear, but it allows a rights abuser to get direct access to data, I don't want that outcome. I want to prevent it. I want to have a little bit of chaos that prevents that result. So as we go back and we start discussing how to make things more clear, how to make things more fair for sovereigns, I hope that we keep in mind that really there might be a higher goal, which is the protection of individual rights.
So Mark Lange.
Hi, everybody. Mark Lang with Microsoft. I'm in the Brussels office and spend most of my time on law enforcement access to data issues. That's my main interest here. I came for two reasons. One, because you promised to get together a number of relevant stakeholders, so thank you for that. And two, because, well, we're involved in too much litigation. And litigation is highlighting the problems, but it's not solving them. So really looking for better ways to do so. Looking for a more coherent rule of law. I'm not sure I would use the term looking for a little chaos, but we do want to serve the different needs of the different stakeholders. Some of the litigation we're dealing with involves conflicts of laws, and that's not just transatlantic, but even within Europe, conflicts involving the different laws in different European countries. And these conflicts, I think there has to be a better way of dealing with. I understand it's not new, and we're not going to avoid altogether. I'm hopeful that our discussions, whether it's about pre-Westphalian models or post-Westphalian models or contemporary ones, can bring some lessons from other areas to help us solve the problems in this area as well. So I look forward to the discussion in that area tomorrow. Thank you.
Thank you. Just behind you.
Gianfranco Incarnato from Italy. I'm from the Ministry of Foreign Affairs, but I will not speak about diplomatic issues or something like that. In my activities, I'm obliged to work a lot with law enforcement agencies, and I would simply like to stress that learning from some frustrations they have, that there is also a growing phenomenon, at least something they exchange often with me. The difficulties in proving unlawful activities are obliging at some point them to dismiss the case, to neglect the importance, to be as far as possible from the problems, because they will be trapped in the pressure, because they must be accountable for the security to citizens, And for many of them, for example, a recent case of cyberbullying, which came at the end of the process with a suicidal effect, was deeply, deeply frustrating. On the other side, they tend also to start delegating these issues to non-law enforcement agencies. And you can imagine what kind of character do they have. They are very effective. They usually do take action globally, and they do also take physical action. They continue to buy people, perfect, efficient, effective people in their hands. They buy governments, they buy everything they want, and they continue to buy all these things by cash, because of course transactions must not be noted on internet. So the fight is harsh, dramatic, and for some of them is already too late, because we probably we certainly need our time, our rules, our frameworks, and this fighting seems to be elusive, at least in a short period of time. But nevertheless, it's very important for me and to be here. I will speak on Wednesday on quite different set of issues, but it was for some time I'm obliged to put my feet on the legal track of these issues, and I found that this is very threatening. Thank you.
And now? Mike is back to you.
Thank you. I want to follow up from Chris. And I haven't heard us here talk much about the digital divide. We used to talk about that in 10 years ago. But what has happened, I have seen, is that there is more intake in connectivity in the global north and less in the global south. People using mobile in the global south. But even in the global south, connectivity is urban, it is male, it is educated. So we have figures from ITU saying, oh, this country has 50% of connectivity, blah, blah, blah. But you will find out all of that is happening in the cities with urban males and educated people. Now, there is something called revolution by silence, in which, I will be going to the data one, in which you decide that this internet thing is getting too expensive for me. And now, of course, most people fear jurisdictions. Once they hear legal or whatever, they cave in. So my point here is we need to work in a way that will make people comfortable to join the digital citizenship. Otherwise, what we'll have will be people who say, this internet thing is expensive, this internet thing is fraught with legal issues, I may be sued here and there, I think I'm just going to leave it where it is and stay where I am. I don't know if I'm the only one who's seen people withdrawing gently from the internet world. And I don't know what happened, maybe because I've been frustrated because I was offline this morning, and someone from IT asked me, what do you think about this? And I just sent a stink. I'm like, we're going to sit in conference rooms talking about very elite people, smelling nicely, and then forgetting about 2/3 of the world. And one of these days, someone was talking about democracy. The people we think, the people we've eliminated by our processes, we end up voting the people they want. Very far-winged, anti-centralized, anti-open, anti-internet people will be the one who will govern all of us. So my appeal here is that let's make it open, let's make it welcoming, let's build bridges, let's let people see the opportunities of what we are doing and not drive them away. And these people are not nicely dressed as we are all the time. So let's make it welcoming as we move forward. Thank you.
Thank you. Who's next?
Hi, I'm Amos To. I'm advisor to the David Kaye, the UN Special Rapporteur on Freedom of Expression. He sends his regards from Turkey, where he's currently on an official country mission. I just wanted to, the kind of guiding post for the mandate is Articles 19 of the International Covenant of Civil and Political Rights, as well as the Universal Declaration of Human Rights. And specifically, we focus a lot of attention on Article 19.3, which states that restrictions must be necessary and proportionate. So some of the questions I'm hoping that we'll be able to work through, particularly in the context of content removal, and specifically in the context of hate speech, is what do the principles of necessity and proportionality look like in terms of governing content removals? Specifically, is the incitement to violence standard something that is tenable, or is something different or less than the incitement to violence standard a more feasible line? And and in that case, we might not actually really need to explicitly clear rules, but we might have to follow Greg's suggestion that we might need something less clear and more evolutionary. And so I think the other question that we have, and we keep encountering in the government access to data piece, respond to some of the concerns that have been raised, is that I don't think there's any question that national security are necessary, is a legitimate aim, and it must be protected, and it's certainly necessary. Restrictions are necessary. Access to data is necessary to protect national security. The question we keep running up against is the proportionality. What kinds of access and what scope of access is required to meet these national security standards? And I'm hoping to see some of that inquiry filter into some of the access to data questions that we'll be addressing today. So thank you.
Thank you. Wolfgang.
Thanks so much. Wolfgang Schulz, I'm a law professor and working with the Humboldt Institute, Internet and Society in Berlin and the Bredow Institute in Hamburg. And I have three observations to share. One was triggered by Bertrand's analogy at the beginning of the meeting when he said to put the internet together to make it work, we need standards and we need some mechanisms to make it functionable. And I think that's a good guiding question for tomorrow when we look at what questions we can really find solutions to and which not. I think the more technical in a broader sense the question is, the more likely is that a community like our network can come to solutions. When it's only a reflection of a fundamental conflict between content industry and internet companies, for example, I think it's less likely that we find more than the right arena or some procedures and mechanisms. I think that's the first point. The second one, in the first round, we talked a lot about court decisions, and I believe a community like ours, a network like ours, can be very good and powerful in designing rules and standards, but what we have to keep in mind is who is actually implementing and deciding, and that's the legal community and judges and courts, which are an important part of the conversation, I believe, but it's also the people in companies that take important decisions. And I think what we have to keep in mind is why should they follow the standards we have developed here? We have to have their decision situation in mind when we talk about these things. And the third observation I would like to share is based on the debate we had in the first round with the Westphalian or post or pre-Westphalian standard. I think that was extremely helpful to see these opposite concepts here, but if we look at the reality of decision making, I think we have already hybrids everywhere, and even the representatives of states, they do not decide the way they did decisions a couple of years ago. They are included into networks, and I think the reason for that is, and that makes us as a group so powerful, is that I believe personally that ignorance is the most problem, the most important problem of the digital society. And I'm not referring to the things happening in the US or elsewhere in Germany, but on a broader conceptual level, I think that's a main problem in decision making, that we have to govern something we don't understand. And that's so important that we bring these different views and backgrounds and pieces of knowledge we have together in this conference. Thanks so much.
Please.
Hi, everybody. My name is Wafa bin Hassin, and I am a policy analyst at Access Now. So I would like to echo what some of my colleagues in this room have already spoken about. Hi, Nana. That this is a very, very broad topic. It is very difficult to approach it from an angle unless you take very specific actions to divide and subdivide these issues into more manageable, actionable items. And a shameless plug-in, at Access Now we have RightsCon, which is an annual event that brings together all sorts of stakeholders to talk about these issues. But I think the unique opportunity that we have here today is that we can actually work on a very specific issue, which is not only jurisdiction, but what that means for different regions in the world. So what Nana was talking about in terms of connectivity. So I come from Tunis, and we talk about privacy of user data by using Uber, for example. In many countries around the world, you can't even use the internet to pay for certain services. In many countries around the world, you don't have reliable court systems to actually bring such issues forth. And I think it's important for us in this room to talk about this while being cognizant of the differences, A, geographically, and 2, based on norms that are cultural and religious, while also separating that from universal human rights that we, as a community of countries, as the world, have agreed to, that these are certain rights that we would like to protect. And that also, I think, goes, you can use that framework to address not only the type of access, for example, that a type of government can have access to, but also in regards to the scope of access, all of these specific questions that we can address. And I really invite you all to just be cognizant of those differences, but also to work together, as we are today here, to talk about what lines can we draw jurisdiction on, and is that even possible? Thank you.
Igor?
Thank you. My name is Igor Milashevsky. I'm from Russia.
If you can stand up so that you can be seen correctly, or is it difficult?
Let me it would be better to...
Okay, let's see if the camera catches you. Sit down, that's okay. Okay. Yeah, wow, well placed.
Thank you. I took the floor, first of all, to mention in the list of sectors who have to participate in this discussion, the technical community, the technical experts. I used to work for government, but I left more than 2 years the official service, and now I'm from private sector. With the colleagues from internet companies, not only in Russia, we created recently the non-for-profit association focused on the development of infrastructure issues and for protecting the industry. And the name of this association is the Open Net with capital N. Let me use the same example with the law enforcement agencies. It's an example that the internet is global since the infrastructure and architecture is global. So, law enforcement agency is looking for a source of some content, and they have URI or URL, which is resolved to DNS. DNS gives the IP address. IP address belongs to the block of IP address. The block of IP addresses is resolved to the number of IAS, and that's it. There is no clear answer, since the autonomous system usually is not located in one country. It is usually in different countries. So it's an example of contradiction between the jurisdiction and globality of internet from infrastructure point of view. So I believe we have to work together to find a solution. And another example is the contradiction between the civil society and the government. If civil society lets the government go, they brings us to absolutism, for sure. This contradiction is solution-proof. It's inevitable. But what makes it the stable construction which works for progress is democracy. I believe we could find the solution in the same way for the contradiction between the jurisdictions and the global internet. In the internet, in the infrastructure of internet, there are a lot of flexibilities, and we could discover it. And mentioning democracy, I would like to express the appreciation to the Friends for Democracy, to Paris, and to Bertrand de la Chapelle for arranging this excellent event. And thank you.
Thank you. Tarek?
Thank you. My name is Tarek Kamel. I am from ICANN, and just to tackle why we are here in the coming few days and today as board members, as community members, as well as staff members, with the globalization of the internet, as Nina has mentioned, and the globalization of the DNS, the question of jurisdiction becomes more and more important for ICANN, and therefore we are glad that we see a whole track that is touching on the jurisdiction and domain names. We also have in the so-called work stream 2, after the IANA transition, a whole team from the community and led by the community that is talking about the areas of jurisdiction with multiple layers. So we look forward for the engagement with all of you in the coming few days to enrich the discussion about jurisdiction and domain names very specifically. And thank you for having us here, Bertrand and Paul.
Thank you. Who's next? Michi? And David? No, Michi. David is in the queue.
Hi, my name is Mishi Chaudhary. I'm a lawyer in the US for free software projects, but I also run a nonprofit in New Delhi. Thank you for being here. What I wanted to urge you guys to remember is that what happens in the US and as you're in Europe has an impact on what the other countries in the developing world look like. This right to be forgotten, which from our point of view was a manufactured collision between free speech and expression and privacy, is not just a slippery slope. Now it has oil all over it and everybody's slipping. We fought very hard for the intermediary liability issues in our country, which is a democratic nation, in favor of free speech and expression. And then we started getting lawsuits where people are coming and saying, hey, Europe has this right to be forgotten. Why can't we have it? And why can't you sanitize the net and prevent everything which is wrong about me on this net? So whatever you will do here, everybody's watching. And most often than not, when it is to raise the standards of free speech, the civil society has the most burden. But when it is to bring it down, then you are cited as an example by the governments which might want to do something else. The other thing which I wanted to say was that let's not get into a situation where our inaction then gets other people to take things into hand, and then the rise of illiberalism, which is now swaying all over the world, gets into a position which we do not want. People off the net are pretty powerful. The network neutrality discussions and access discussions in India actually show what the people power can do. So that's a lesson to learn from. This discussion about MLATs and chipping away at that with the US-UK agreement really bothers people like us from another country. Because what happens is if you're going to make deals about data sharing, let's not do it with countries who do not even have privacy as a significant subject of law. If they're not even willing to recognize their citizens' right of privacy, I do not think that this data sharing is going to go the same way as perhaps nations which do have structures of rule of law and, in fact, judicial review are going to see it. The words will mean completely different things on the other side. And last but not the least, the most important thing, because we talked about access earlier and Nena brought it up, is there is blanket internet shutdowns which are happening. As of October 2016, India has shut down internet 46 times, which is just not one website being taken down, not one app being taken down, but mobile or wireless taken down for either curbing violence or public mobilization or something else. This is something which worries us because there is law on the books which actually allows for such a thing. Even the Supreme Court says this is fine in certain conditions. So when we talk about access, we also need to be aware that there's this gradual normalization of this trend. Before the election, let's shut it down. There is a place which you do not like what people are saying, let's shut it down. Thank you.
Thank you. Martin.
Thank you, Maarten Bottemon, independent analyst, and also since recent on the board of ICANN, speaking in personal capacity. I'm very happy to be here because this is not an easy subject, but this is a subject we need to start dealing with. What struck me here in all the good things I heard is, again, and thank you for that, the realization that we are not representing the world and we are not fully aware of the needs and the importance of the world. So in the discussions, please take into account that whatever the problem is, jurisdiction is of course the task of governments, but they cannot do it alone. We need to have a multi-stakeholder approach here to solving with these issues. The second issue with regards to understanding the world, those people that are not online yet, we speak for as well, and we need to take that into account. Capacity building and awareness raising should be a major priority, and that is not a monopoly for governments to take care of. We are very, very well placed to do that together, and we need to do that to make sure that the solutions we come up with are not just reflecting our values, but also will be applicable wider in the world and will actually work.
Thank you.
Okay, Corinne McSherry from EFF, and since I went long last time, I'm going to be really short this time. I just want to interject that I think it's very, very important that, and I think Chris Riley was referring to this as well, it's very, very important that we make sure that we have technologists in the room as we have these discussions. I suspect a lot of us are lawyers and policymakers, and I love lawyers and policymakers, but we won't always have the technical perspective that we need to make really smart decisions and recommendations. So I would urge, as these conversations, not just in the next few days, but as these conversations continue, that we find ways to make sure that we're consulting with the technologists, because consulting with technologists, at least in the United States, was pretty helpful in stopping some really bad laws recently. And so I know from experience that it's a good idea to talk to the engineers. So that's my comment.
Thank you. Who's next? Please.
Rama from DSCI in India.
There's just a brief comment that I want to make, at least in tomorrow's breakout discussions. We take cognizance of the fact and be wary about the increasing tendency for liabilities on intermediaries, because the intermediaries quite often are startups and small emerging content and service providers, and we may be scaring them away from offering their services and solutions on the internet, which is the best way for a startup to reach their consumer base or the customer base. So if we can put some focus on this, what we are noticing as a little worrying trend on liabilities being shifted to the intermediaries.
Who's next? David?
Thank you. My name is David Post. I'm the law professor in the United States at Temple University in Philadelphia. A quick note on why I'm here. So I wrote an article about 20 years ago about jurisdiction on the internet, and naively thought that we should have a conference about that subject like the next week, I guess, or wait a month or so and then really tackle it. And it's taken 20 years. But that's a good thing. Because I think we needed the experience. We needed to see what we were talking about, actually, and to get the experience of what these problems are and how they're playing out. So here we are. I just wanted to pick up, there's a lot of interesting issues, obviously, being discussed here on these different tracks. I wanted to pick up on two comments. One, and I apologize for not picking up on anybody's name, the gentleman from Mozilla and the woman from Wikimedia, about the needs of internet users. It's not just, the problem facing us, I think, is not just that France and the United States may have different laws about hate speech or data privacy or data protection, etc. It's that there are online communities themselves that may have their own rules and norms about these issues, and that part of the non-Westphalian, neo-Westphalian, pseudo-Westphalian system that we need to absorb is that lawmaking communities themselves are now not necessarily territorially based. And these communities are such that users may be exercising their right to participate in the formation of the rules under which they conduct their businesses or other aspects of their life. And I think Bertrand was pointing to Wikipedia as one of those, that type of community that is setting its own, collectively setting its own norms. So I think one critical set of principles that we need to be thinking about and needing to develop is not just how we reconcile the laws of different territorial sovereigns, but in what circumstances should territorial sovereigns defer to the rules of these non-territorial communities. This too is an old problem in the law. We faced it with respect to religious communities in many cultures for many years, but I think that also is one of the critical issues that we need to address here. So I'm glad you're all here, and thanks for listening.
Thank you. Agnes?
Good afternoon, everybody. My name is Agnès Calamar, and I run Columbia Global Freedom of Expression at Columbia University. I want to highlight an issue that I think has been covered, including by the previous speaker, actually, but maybe put it more forcefully. You have framed the challenge as very much a challenge of jurisdictions. So far, and the Westphalian system against the borderless nature of internet. And there are many reasons for doing so, many very good reasons for framing the challenge as being one of jurisdictions. However, I will suggest that maybe a greater challenge is one of norms and values, and that what we are currently framing as a problem of jurisdictions is actually a conflict over norms. We may be overly driven by the challenge to the Westphalian system in the context of the deconstruction of the multipolar system or reconstruction of the multipolar system. But actually, this construction is also, in fact, primarily, I will suggest, given the range of elections we've seen over the last year, is primarily a conflict over values. I think one of the challenges we are confronting is a challenge over norms and values. And by this I mean as well the challenge that a new generation of internet users, internet entrepreneurs, norms entrepreneurs are bringing vis-à-vis the norms that had been part of the internet for the first and second generations of the entrepreneurs of the internet. So we are, in my opinion, confronting probably a more complex, if there is anything more complex than jurisdictions, but I think there is something more complex. And I would like to highlight the fact that the court cases that have been mentioned, and I happen to be monitoring, as you know, a lot of court cases around the world through my initiative at Columbia University. Of course, the biggest court cases that are making the headlines are those that are involving jurisdictions conflict. But the majority of the cases that are about internet are about values, are about norms at domestic levels. And we should not overlook the fact that there is a real challenge at the moment to the first and second generations of norms. And I think it's also linked to what you were saying earlier about those new users coming in, and the new entrepreneur, as I have said, the new constructors of internet, the ones that want to take ownership of internet, that are coming with their own norms and values inside that system. And I don't think we should overlook that particular dimension of the challenge.
Thank you very much, and yes, Keith.
Thank you very much, Bertrand. My name is Keith Drazik. I work for VeriSign. We're the registry operator of the .com and .net top-level domains, among others. I just wanted to take the opportunity to echo some of the comments from colleagues from EFF and Center regarding the need for technically informed decision-making and discussion. And I'm quite sure that technical operators of the DNS and other elements of our ecosystem would be more than happy to participate in helping to inform and educate some of the policy discussions. I'm a policy person, I'm not a technologist or an engineer, but I will say that I benefit greatly from conversations with experts in my own company to better understand the implications of our discussions. I think one of the challenges that we see as policymakers and government officials is that in many cases, our efforts, our discussions are overtaken by events that take place in the technical sphere or in the engineering sphere. Conversely, I think it's really important that as we move into tomorrow's discussions, that we keep in mind that whatever structures we try to develop around the 3 work tracks are implementable. And that gets back to the question of technically informed discussions, but also flexible. We have to remember that this is a shifting landscape. And I'll give you one example to illustrate. In 2012, there was a policy passed at ICANN that was going to that requires all registry operators to go to a thick whois. And a thick whois, for those that are not familiar, is really about the registrant data, the customer or end user data, being held in a central location at the registry. All other registries are currently thick, but .com, .net, and .name are the 3 that have yet to go thick. They're considered thin, where the registrant or customer data is held by the registrar, which is the retail point of purchase. So that policy was passed in 2012. There's been implementation work, an implementation team working to basically get us to the point where the registrars and the registry, wholesaler and retailers, would have an agreed to set of processes for transferring that customer data, that registrant data. Of course, in the interim, since 2012, we've had the Snowden revelations. We've had new legislation and regulation coming out of various jurisdictions, including the European Union. And questions have now been raised, is how do we manage the bulk transfer of 140 million domain name registrant records around the world, including in the United States, from registrars to the central registry that is located in the United States. And so there are discussions going on now about how do we accomplish this? Can registrars be exempted from engaging in transfer of data? Some registrars are suggesting that instead of passing actual customer data, they would send us proxy data to the registry level, which sort of undermines the policy. So I know I need to wrap up. I just want to note that these are important discussions that are taking place, so we need to remember what we come up with needs to be implementable and flexible to acknowledge and accommodate the changing landscape. Thanks.
Thank you, Keith. And it's actually a good moment to say, if you want to make comments when you take the floor on what you expect to see tomorrow, or the same kind of comment that you just made, that's welcome. Who's behind? No? So, who's next? Aha.
Yeah, thank you. Thomas Fitschen again. I wanted to react to the comment just made by the lady from the University of Columbia about the level, that there is a distinction to be made between the level of jurisdiction and the norms and values behind this, maybe sometimes hidden. Yes, our discussions so far sounded as if it was just a matter of procedure. If we only got the jurisdictional procedures right, then everything would be fine. But of course, sometimes governments would just love to see difficulties because then they don't have to cooperate. Let's not forget that there are always some governments around the world, some countries, that we are just happy not to cooperate with for political reasons, for value reasons, for legal reasons. So, and of course, neither governments nor the internet community is naive about that. So it's not just about procedure, it's indeed about what is behind this, what are we trying to defend and what are we trying to enable, and what should we try to prevent from happening also. Let's not overlook that. Thank you.
Xiaohong.
Thank you very much, Backtown, for inviting UNESCO. My name is Jian Hong from UNESCO. As Backtown and Paul mentioned that our Assistant Director General, Frank LaRue, is being late for the conference. And before that, I'd like to give a few of my two cents to the discussion. I've been following this project. I'm in the Internet Jurisdiction project for quite some months. And I truly appreciate in terms of the multi-stakeholder spirit. As we see today, it's such a roundtable setting here. We hear all the equal footing speech from different stakeholders. And my first reaction to the discussion so far is that I do echo with several speakers, actually many interventions about the aspect on the free speech and the free expression, because I mean all three work streams, I mean ranging from the data privacy to content to DNS to the content takedown, they all have such a wide and profound implication on the free expression, which is a core mandate of UNESCO. I've been working to defend it online, offline, also free information, which means the public access to information when it's impacting the public interest information on the internet. I mean, so many measures now taken by the states, ranging from the countering terrorism, from limiting speech and also hate speech, etc., which are all our concerns. That's why that's one aspect I'm expecting tomorrow's discussion will be addressed, which means that, I mean, to look at the cross-cutting implication on the free speech, free expression by all work streams, because eventually they all have such impact here. And secondly, I want to inform that actually last year, UNESCO has taken privacy as one of our new mandates and tasks for its future agenda on internet governance. We position ourselves in a aspect that free expression and the privacy, they are really friends. They are not in conflict. They support each other. without a free expression, we cannot defend the privacy without and vice versa. That's another position we'd like to share. And thirdly, we also want to see is to look at its jurisdiction, to look at all this work stream from a much even bigger picture. As also Bakhtan mentioned, that we see the internet as a public good, and also many speakers echoed that we should not compromise compromising, fragmenting internet along the border of jurisdiction. And our member state has endorsed a new position about internet universality framework, which will call for internet based on all human rights to be protected. Openness of internet and accessible by all internet, and also the internet driven by the multi-stakeholder participation. So I think I full stop here by multi-stakeholderism of the internet, which also was well practiced by our internet jurisdiction project. I look forward to more interaction with all of you tomorrow.
Thank you very much. Anya?
Thank you. My name is Anya Kovac. I work with the Internet Democracy Project in Delhi. And though the representative from Germany just addressed some of the points I wanted to make, I'm going to strengthen, I think, some of the comments that have been made earlier. And there's 2 points I wanted to make. The first one is that we are having a conversation here on the assumption that having better procedure is indeed the better thing to do at the moment. Several people have asked that question, can we afford not to? And kind of presumed that the answer is no, we can't afford not to. I really think that's not that clear. There is a growing domestication of the internet, which has been going on for quite a long time. Actually, this is not new. But setting up new procedures for this kind of collaboration actually will aid that kind of domestication as well. And in a context where we see, as some others have pointed out before, that the rule of law doesn't apply everywhere in the same way, that can create new challenges and risks, especially for human rights, as much as it solves problems, especially of security. I also think, though, it's important not only to single out countries, developing countries mostly, where the rule of law might at times be weaker in implementation. I think we see the legal framework around how human rights actually apply on the internet evolving everywhere, not only in the developing world. This is not a settled question. And actually, in practice, we see that many developed countries as well often privilege security over other human rights. Do not see security as integral to human rights. And in that context, again, I think as these questions are not settled, we really need to see that the procedures we come up with will also play into that larger debate. I understand that there are risks to inaction, but we should also not think that any kind of action is necessarily fine, and I think we need to see the synergies going forward also and take into account that there will be implications that we might not immediately see. And the second point I wanted to make was about the importance that geopolitics also plays in actually making solutions acceptable. We did an assessment of the reasons why India should or shouldn't sign the Budapest Convention, for example. And out of our paper came that most of the reasons that the government considers are actually geopolitical ones, more than to do specifically with law enforcement. I think it's really important to think about how any solution we come up with actually also can avoid those kind of complications going forward. There's also legitimate questions about, for example, the US-UK draft bilateral agreement. While an interesting initiative, I immediately had concerns about what that means for the standard setting that they would do for the entire world if that initiative is positive, if it is expanded to other countries, etc. Again, kind of bringing into play some of the earlier questions about what happens when a small club of people or governments actually set standards going forward. So I think it's important to take these questions into account explicitly. Thank you.
Who's that? Mike?
Thank you. I'll be brief. I just wanted to acknowledge Zhu's comment about how privacy and freedom of expression are often good friends. I would make the statement more strongly. I think they're complementary values, and as strongly as we support privacy, we also support freedom of expression. We believe it's necessary to avoid the zero-sum balancing language that's sometimes used in this context. And to make a related point on the issue of internet shutdowns, we think it's vitally important that there be a democratic process established to determine the circumstances when internet shutdowns occur, that it be made transparent and that it be made accountable. This was actually a lawsuit that Epic brought in the United States against the Department of Homeland Security when the telephone network was shut down at a San Francisco subway station during the time of a political protest. And we said there may be some circumstances where such a shutdown would be justified if, for example, there was a concern about the remote detonation of a bomb. But the policy criteria, in other words, those circumstances which would justify such a shutdown, absolutely had to be made public. So we brought a Freedom of Information Act case in the US. We actually won in the lower court. The agency would have been required to reveal the information to us. They appealed it and then went on appeal. So I was disappointed. But the lesson, I think, to others is that this is a process that absolutely requires transparency and oversight.
Thank you. Stefan.
Thank you. Does this work? Yeah. My interest was piqued when we were having the discussion about the need for expertise, technical expertise, to be in the conversation and to be in the room. Aside from the consulting that I mentioned earlier, I've also been heavily involved in the domain industry, both as a registrar and as a registry. And one thing that's obvious at ICANN, and certainly at ICANN leadership at the board level, is that the notion of conflict of interest is one which is hard to solve, and the communities had a lot of difficulty in trying to get to grips with it. So, for example, when we talk about experts, technical experts providing feedback, we're obviously going to ask that they provide unconflicted feedback. But most people, or most technical experts that we tend to hear from are, like we've had today, from small startups like Google, VeriSign, or Microsoft. So we're not hearing the technical needs and requirements of smaller enterprises, and in the case of the industry that I know, registries and registrars. So a question that I have, we're asking questions right now of what we'd like to see evolve or come out of the discussions tomorrow, is how to equate the very clear need for technical expertise. I mean, it's an absolute given that there is need for technical expertise. And to take ICANN's case again, I think ICANN has fallen short of the technical expertise it needs, certainly at board level in recent times, because of this desire to be free of conflicted interests. But how to balance this need with the requirement for this technical expertise to be given freely without any self-interest at all, and to defend the interests of everyone that's using the internet, and not just a fringe, be it a large fringe because it's a big corporation, of that internet user community. Thanks.
Yeah. Yep.
There. Bill Woodcock, PCH. I wanted to address specifically this question of whether we are ready or whether it is premature or whatever. I can see how, if one is just joining the conversation relatively recently, it might seem like there are many questions still to be answered before a specific path forward might be selected. But if you were on the receiving end of the fire hose of requests, you would not have that doubt. The millions and millions and millions of requested transactions which are coming in by phone, by fax, by email, by registered letter, by word of mouth, all of them with different kinds of information in them, formatted in different ways, all of them missing different kinds of critical information that are necessary to be actionable. We are 30 years into this problem, and it continues to get worse and worse. we are 4 years into the specific conversation that Bertrand has been moderating, and it continues to get worse and worse. This problem needs fixing urgently. And the question of whether we need technical experts in the conversation, there are two conversations here. One is about the policy adoption and getting law enforcement and government to use such a system. The other is about the establishment of technical protocol and its implementation. That's an IETF process. The IETF knows how to do this. It's been doing this for 30 years. Not this specific protocol. Similar protocols have been tried in the past several times and have not been paired with the necessary political effort. What is likely to succeed here is the pairing of this political and policy and diplomatic effort that's happening in this room with an IETF protocol effort. Both need to be done in order to succeed.
Nicholas?
Thank you. Yes, Nicholas Lundblad, Google. I just wanted to address one question that Bertrand raised early on, which was what happens if we do nothing? What is sort of the zero scenario? And I think it's quite interesting when you look at a social system where the rate of change exceeds the rate of learning, the result is an increasing randomness in decision making. So what you end up getting is not exorbitant jurisdiction as much as arbitrary jurisdiction, which naturally breaks much of the legitimacy of the system and much of the value system that we want to preserve as well. So I think that one really important thing is to figure out how can we then address this rate of learning. And I think Wolfgang Schulz was on to something really important here, where Professor Schulz said that ignorance is one of the main problems. Now, ignorance, like the future, like William Gibson used to observe, is unevenly distributed. So one thing that we could actually do that would have a high return on investment is to identify those centers of ignorance that are out there and try to address those with specific educational content, for example. I think it's a low-cost, high-impact thing to do, and I think it's not been done enough. So that's just what I want to say.
Who's next?
Hi, everyone. My name is Jacques de Vera, and I'm a professor at the Law School of the University of Geneva. I actually wanted to get back to the third issue that Bertrand mentioned in his introductory word, which is who gets to adjudicate internet-related disputes, and more specifically content removal disputes. Because my perception is that we somehow tend to look at it in a too stringent binary way. Either we say this is up to the court, and then of course we heard a lot about the inefficiency of this approach, which is too slow, too costly, too fragmented, of course. And at the other end of the spectrum, obviously, we may consider, and that's also something what you've heard earlier, the platforms can decide. And this is, of course, not optimal. This is basically the point that you made. Now, what I want to put here for discussion, and actually for discussion tomorrow, is that there is a middle way, potentially, which is something on which I think we should all work together, which is ADR. Alternative dispute resolution mechanism, of course, in the sense that there is, in general, a need to implement this system in a voluntary manner, and that goes back also to a point which has been expressed earlier. And my perception is that we don't have to start from scratch. We've already had good experiences with online dispute resolution mechanism for solving global issues. Of course, everyone knows about the ODRP. Obviously, this is not the ultimate system, but still, this is something which, from my perspective, would need to be further explored. And also coming back to what we heard earlier in terms of standardization, we should think about ADR system which should ideally be in a position to solve all types of content removal requests, talking about IP, talking about data protection and privacy, and make sure that we have some kind of a common ground in terms of procedural fairness and due process elements. And in that respect, I also wanted to mention that we are working on these topics at the University of Geneva, and this is basically an open invitation to all of you who are interested. Sorry for this showing this. You can find the flyer outside of the room. If this is of any interest, I'll be very happy to discuss with you to what extent we can somehow contribute to that discussion, not in that binary approach, but trying to explore that third avenue of ADR. Thanks very much.
Just one point. Jacques is timid and he didn't use, or I misheard it, a wonderful expression that he has coined about the kind of problem that we're confronted with. He calls it massive online micro-justice. And I think this is a very nice qualification of the problem we're facing.
Thank you.
Benedicto.
Thank you. My name is Benedicto Fonseca. I'm from the Ministry of Foreign Affairs of Brazil. I'd like to respond to the question, why are you here? So for a number of reasons. First of all, I was kindly invited to come, and I thank the organizers for this. Another reason is that at Net Mundial, which we were very proud to host in 2014, the issue around jurisdiction was one that was highlighted as one that deserved more investigation, more attention, and we are very glad to see a concrete follow-up through this project and through this conference. And we are very happy to contribute. I'm also joined by a number of members of the Brazilian Steering Committee. Another reason for me particularly, I'm honored to be chairing a working group on enhanced cooperation under the aegis of the CSTD. And I see a very clear link between what we are discussing here and the mandate we were given to try to shed some more light on this concept of enhanced cooperation, which basically refers to the notion that governments should come together on equal footing to discuss internet-related public policies that do not relate to the day-to-day activities. So it is completely linked to this idea of how governments can come together and overcome and address the issues that relate to jurisdiction and consent on how to put in place mechanisms. Of course, working also in a multi-stakeholder environment with the feedback of other stakeholders. And one final reason is that we think we are very glad that the ICANN transition took place, the transition around the surveillance over the IANA functions. However, we think that the discussion around the ICANN transition is not over, as Tarek Kamel has spelled out. The issues around jurisdiction is also a very important track to be followed in the second phase, in the work stream 2. We think there are a number of issues, as Tarek has said, that it's a multi-layered discussion involving many aspects. One aspect for us that is very important is how to reconcile a situation in which ICANN was established unilaterally under a single jurisdiction. The mechanisms to work the IANA functions have been addressed, but not the issue related to how to reconcile this issue of jurisdiction with interests that may be not be seen as being completely addressed under this jurisdiction. No one was asked in the first place to accept. So there are some issues around that, especially in regard to the settlement disputes that we are very willing to investigate and to work with colleagues. So I think for a number of reasons, we think this conference is of paramount importance. Thank you.
Thank you very much. Rod, I think.
Hello, my name's Rod Rasmussen, currently with Infoblox, but I am one of those technical experts who was a small startup, so that's here can be neutral. But to be fair, I think there are several technical experts in the room, and I think we all try and be neutral when it comes to these issues, just like all the rest of us in our professions try to bring that, especially in a conference like this. I think we're doing a pretty good job with that. I want to thank Bertrand and the whole effort here for bringing this room together. It's important. One of the things that brought me here, besides being technical expert, whatever, on this stuff, is that I've been doing these, what was it, micro justice activities on a massive scale. So my company, myself personally, but my company is probably responsible for takedowns of well over 1 million things on the internet, right? Over the last 10 plus years, yeah. Probably millions. I don't know what the actual number is off the top of my head. So, you know, we have a little bit of experience at this, and it's not that, and the things that we deal with are typically what I would call the weaponization of the internet, which is phishing and malware and all these things that I think pretty much everybody in the room can agree with we don't want having, infecting, and doing things to our computers that then reveal privacy or steal money or put people out of business. And that's, so that dealing with those issues over the years, we've seen this evolution where you have actually seen kind of this this underground system, this system that's just been set up because people need to deal with problems, and they will deal with them, and they'll come up with technical solutions. That's where you're seeing the rise of blocking. They will come up with operational measures, and that's why you're seeing networks of communications being set up between companies so that they can deal with these problems. So that is done typically trying with a look towards what the laws are, but again without this massive amount of laws that you have to deal with all the different jurisdictions out there. It makes it very difficult to come up with things that work 100% all the way across the board, especially once you start getting out of areas where there's 100% universal agreement. This thing is something that needs to be dealt with. So phishing, malware, child exploitation, those are kinds of things that are fairly easy for people to agree on. Once you start getting into those things that are legal in some places and gray in others, it's very difficult. So taking some of those solutions that we have come up with for dealing with those really hard, nasty problems that we agree on is one of the areas I think that we need to explore more. There have been some good efforts done in that area with trusted intervener programs and things like that. That's the area that I hope that we can explore some more with this group. Thanks.
Thank you, Ron. Please.
Good afternoon. My name's Greg Callis. I represent nobody but myself, but the hats that I'm wearing here, I'm the editorial ombudsman at the Financial Times. I come from a journalism background. I'm now a barrister in a set of chambers in London specializing in media law, primarily defamation, privacy, data protection. I'm also currently working towards a PhD in digital technology and conflict of laws. So my reason for being here is if you can all give me 500 words answering tomorrow's questions, then that's pretty much me done. I have to begin by some special pleading, which is I do a lot of work on production orders, whereby law enforcement and security services seek access to journalistic material from my broadcasting and newspaper clients and other online media. Media have become honeypots of information on certain things that law enforcement needs to look into, where they're running stories on people who have gone to fight in Syria. They understandably want to know all about those communications. We're very lucky in English law that there are very high levels of protection for journalistically privileged material, but also material that is covered by legal professional privilege. Insofar as this conference is interested in access to information, whether from media and lawyers or from intermediaries whose customers are journalists or lawyers, a little special pleading from my two professions that these should be particularly high in your minds. The one thing I wanted to address very quickly, thinking from a research perspective, is defamation, copyright infringement, hate speech, and privacy are, as it were, private law torts, but there are plenty of jurisdictions where defamation, copyright infringement, hate speech also cross into the criminal territory. We heard from the lady from the ministry in Spain about the recognition of whether her administrative agency would be recognized in the same way as a law enforcement agency or a court. The distinctions between private and public are starting to break down. I'm not sure that we have a perfectly delineated split between what belongs to private international law and public international law. And in jurisdictional terms, I think that's particularly important, because whatever is done in the public international law and law enforcement jurisdiction sphere private international law will have to follow. I actually, in the Cartier case about web blocking, which was mentioned by Jane from British Telecoms, because the technology was there to stop criminal child abuse images appearing, and that could be blocked, therefore it would in time be used first for copyright and then for trademark. So I think we have to be cognizant of the impact of anything decided here in the public jurisdiction sphere as to what the consequences will be in private law. I happen to believe data protection in particular is dissolving that barrier yet further. The one perhaps plus side, and I'll finish in 10 seconds, is that insofar as that distinction between private and public approaches to jurisdiction is becoming ever harder to enforce, perhaps in trying to solve our problems on the public law side of the fence, we might actually be able to find some solutions, ADR or otherwise, from the private international law side of the fence.
Thank you very much. We're actually, first of all, thank you for having been so amazingly disciplined in the acceptance of the time constraints. We were a little bit anxious before this meeting on whether it would work. I hope you didn't feel too constrained. Before you were allowed to go to the cocktail, which is waiting outside. I want to pick on a few things. It's not a summary of what has been said today, but I hope you appreciate it as much as I did the interactions. It's substantive, and it's also showing a commitment that we hoped to witness. I won't belabor on the perception of the importance, how much it touches on the daily activities and so on, and the urgency to deal with it. I think the message was clear, as we hoped, but it's great. We'll have to delve deeper, and I'm very happy about it, on the question of Westphalia. And on the question of, I liked very much the balancing in a certain way between Westphalia doesn't adapt to the internet. No, it's internet that doesn't adapt to Westphalia. This is exactly what we were trying to highlight in the first comments that we made about the reconciliation. And I was mentioning to Thomas Fitchen outside the analogy that I'm making, and sorry for taking a couple of seconds. If you want to build a bridge today, you can still do it with Newtonian physics. They are 400 years old, but they still work. If you throw this microphone at light speeds, you need relativity. And if you want to examine the atomic structure of my pen, you actually need quantum physics. Each of them has different levels of validity and zones of validity. If you have a Frenchman, to take, as we're in France, if you have a Frenchman insulting another Frenchman on a French platform in French, and they all live in France, there's no problem of international internet jurisdiction. It's French law, French courts, period. If, on the other hand, this very same Frenchman is traveling in the United States and is insulting an Australian who is traveling to Peru using an American company and so on, then you get into more troubles, and then the question of multiple overlapping jurisdictions come in. And one of the challenges is, as we were discussing as well, it's not that jurisdictional problems did not exist before. Of course they did exist. I see two things that have emerged in the discussion. One is the scale, is that it's becoming really the norm, and Jacques de Vera was mentioning it. And the second thing is that in most conflicts of law situation, we used to be accustomed to having to decide which law applies, A or B. But if you think about GOIP filtering, for instance, that a lot of people are going to discuss in Workstream 2 tomorrow, you're actually accepting law A and law B. And if a company is actually filtering in a different way in country A, country B, country C, country D, they're actually respecting many different laws. And so it's a much more complex situation. Another thing that was mentioned is, and I think it was Greg, the question of efficiency and clarity, and the desire to have clear norms, but at the same time, the fact that what we want is to embed human rights in these due process mechanisms, and that actually it's an opportunity to raise the bar for everyone. And it's again a non-zero-sum game. I want to pick, by the way, I love the expression zero balancing. I like this notion that it is not about diminishing something for the benefit of something else. It's trying to raise the bar in different places. Another quick thing, the engineering approach, I would make a connection with something that, you remember Lawrence Lessig saying code is law? I think in the discussions that we have, we need to take into account something that would be the reverse, i.e. law embedded in code. There are things that technically can facilitate the respect of some rules that have been agreed upon, and things that, on the contrary, can prevent the laws from being applied. And finally, still in the, there are many other things, but two expressions that struck me as well. One is domestication of the internet, because when you look at the word domestication, it has a lot of ambiguity in the meaning, and I think unfortunately we can witness both. I think that's why we chose it. You chose it. And the other one is the notion of arbitrary jurisdiction, which I think is more important indeed than the excess of jurisdiction. With that, Frank Larry is somebody who does an absolute perfect timing, because he has managed to manage the closing speech for this. The penalty is that you will have less than the 25 minutes that we had intended to give you. But if you want to say a few words at the end, please, we are very happy to have you. And if somebody can give a microphone to Frank.
Thank you, Bertrand. And I promise I'll be very brief. I know it's been a long day. Let me apologize. We had one of these very long UNESCO dialogues with member states, and it went on.
And he looks at Yanis, which means a lot.
Yes. And it went on forever. So it was very good, very helpful, but very lengthy. I apologize for the timing, but I still came in the nick of time. Two things we wanted to mention here. Some, I think, have been mentioned by Shangho, my colleague, already. From the UNESCO perspective, we're very eager to look at solutions that deal with procedures and the due process around the world, internationally. But at the same time, we're very cautious. And very cautious because we have a rights-based approach on everything we do. UNESCO has three mandates: human rights, a cultural approach, and an ethical approach to all issues. And in that sense, we try to look at internet from all three, from a human rights perspective, well, a technical perspective, of course, an ethical perspective, a cultural perspective, and a human rights exercise. And in that sense, we're very interested in internet being, number one, a facilitator of one big bottom line right, which is the access to information. And we believe, when people ask me what is the crucial element of the sector that I am the director of in UNESCO, the sector of communication information, I said, really it's freedom of expression, but it's all its aspects. The right to seek and receive, and to have access to information, and then to impart and share information. And this is the crucial element. So in this seek and receive information, there's a couple of elements. We're members of the Broadband Commission, for instance. We partner with ITU in this. But we have a slight difference. We're very close with ITU, and we have a great coordination. But for ITU, it's a technical problem. How we build connectivity for all those billions of people that are still not interconnected. For us, it is, yes, how we guarantee connectivity to everyone, because we want everyone to exercise equally the right, but also how we guarantee the relevant content that everyone deserves. Just the connectivity would not do the trick. It must be connectivity and substantial content. And now that we're looking at the SDGs and the new 2030 agenda, we insist that before access to information and communication through internet was seen as a fundamental element of freedom of expression, as a human right, was seen as a fundamental element of citizen participation and therefore of democracy. But today we're all very clear, and no one will challenge, we see it also as a fundamental element of development. All 17 SDGs and development in general, as well as the Paris now the Paris Agreement on climate change are only reachable if we guarantee communication to the public. We said that the Millennium Development Goals, for me, failed because they were never appropriated by the local communities. They were a great plan, but it had two faults. One, it was designed by the developed nations to the developing nations, and number two, that they never reached, in the level of communication, they never reached the bottom. They never got to the local communities to make them theirs. And development is only possible if a community assumes this agenda as their own and implement. This means communication. Now, for everyone to exercise this right to access information for their own development and for their own benefit, it also means to guarantee the connectivity, yes. It means you have to guarantee equal service to all, not making a difference of economic origin or cultural or racial origin, for which we also believe in the neutrality of the internet, and we have defended the internet. It also means that you respect the privacy of these communications, so it means that there's another right that we're exercising, the question of privacy. And yes, we must combat incitement to violence, and we must combat extremism and violent speech and hate speech, but at the same time, we must guarantee privacy. So it's a very difficult situation because we have to define. When I had the mandate of rapporteur, I drafted a report on hate speech, precisely establishing what we consider were the five we have the three-part test in general to understand what is acceptable as a limitation, but we went beyond that to generate 5 benchmarks where to define where the state could intervene because it was speech or a message that could provoke real harm, real either violence or discrimination, which are the terms used by Article 20 of ICCPR. There was 5 elements that we insisted, which was there has to be a clear intent. The intentionality was very clear. The content was very relevant. There had to be very clear, defined content that would provoke this harm and that would circulate wide enough to reach out to enough people to provoke this harm. It had to have the incitement to some specific harm that would be feasible and possible. The 4th was that this harm should be imminent and not way down the line. And the 5th was that the environment and the context was very relevant to this harm to occur. And in this sense, this gave sort of a certain degree of standards. We still fall, and this we have discussed with our friends from the Universal Jurisdiction Project now, that we have discussed this issue a lot. Now, what do you create as a common standard for around the world? It still becomes very difficult because obviously it would be ideal to have a state authority to participate. You have the problem of the quantity and the amount of cases. But on the other hand, you also have the problem of whether you go to the judiciary, what will be the definition of legal standards around the world. And here, the only solution we find is that we are very flexible on the cultural relativity. We believe that culture has to be a fundamental element of communication, and culture diversity is important to be reflected in internet, but never to limit the exercise of basic standards of human rights. And in human rights, there can be no cultural relativity. And this is very important. This is why human rights are universal, and they are in a specific standard across the world. Human rights are based on equal dignity of human beings, and we can make no exceptions anywhere. So this is one of the big conundrums because, yes, we have to be able to establish some levels of procedures that can vary in terms of legislation in different countries, but at the same time, we have to guarantee that the domestic legislation is in accordance with human rights standards, which is one of the basic principles of human rights. All states have to make their domestic legislation in accordance, have to update their domestic legislation to make it in accordance to human rights standards. So this is something that we will definitely insist in. This was a debate I had strongly in Thailand, for instance, because of the lèse majesté law. For instance, they told me, look, this is our tradition. We have an 800-year-old monarchy, continuous monarchy. We have never been colonized nor conquered. Therefore, we have the right to protect our monarchy. And I said, look, I understand the pride you must have a nation. I understand that you must protect your stability and your monarchy, but that does not mean that you can limit freedom of expression differently than what is established as a common standard for every single other part of the world. Any public official can make mistakes, even the king, in any part of the world.
And you went to jail?
Again, yes. There's 5 years of imprisonment for every time you mention the king, by the way. So this, I just wanted to make that very clear, that we are engaging in different process of dialogue, and we do engage in different mechanisms, but we believe that there have to be issues of facilitation. And let me say finally that the clearest example of this, and here I know I'm threading in the fine space, was the so-called right to be forgotten, which we don't agree on the name, by the way. That right does not exist, but on the decision of the European Court. Although we believe the decisions of courts must be respected, we disagree on the fundamental elements of this decision for many reasons. Initially, because we believe that the information was actually very relevant. If you're going to hire someone, you do want to know if someone went into bankruptcy or not. It is very relevant to see if you want to hire him as a manager of your company or not. But having said that, the most important question was that the court decided that because of the volume of cases that could come, they would transfer the responsibility to Google. And this is a mistake, because the state can never refuse to handle their own responsibility. So there had to be some complement between, yes, corporate responsibility, which should play a role. I'm not denying that there is a role because of the amount of cases, but also some degree of guidelines and responsibility by the state. The state cannot just simply transfer its responsibility to uphold human rights, including the prohibition that Article 20 has of hate speech, and transfer it to a private actor.
I think that will be a huge part of the discussion that will take place in Workstream 2 tomorrow, and particularly on content removal and in general, because it touches on the
It is more to come.
Yeah, it touches on the responsibility of intermediaries.
Perfect. And the final point with this I finish is that the decision also made it very clear that they wanted the decision to be implemented worldwide. Very dangerous. Google said, no, we respect the decision, we apply it in the jurisdiction of the court, which is the European jurisdiction. A very dangerous proposition, because obviously it is the European court. Generally speaking, everyone in Europe would have trust in the European court. But what happens if the next decision is from a court elsewhere, in a very high-powered country, but of other parts of the world? Would the entire world be willing to apply that decision of the court? I just leave the questions.
I think you should have a dinner or drink with Nicholas, who was just there. Might be somewhat on the same line, I guess.
I'll have more than one drink, thank you. So, in principle, the conclusion is we believe internet should be very flexible, but we maintain the universality, the neutrality, the human rights approach, and the fact that we should keep very common standards around the world for everyone to enjoy an equal right to access information.
Thank you, Frank. I'm very happy that you could be there for the end. Before you stand up, I just want to introduce the moderators and the rapporteurs for the work streams tomorrow. That will start at 9 o'clock. There will be croissant before, so you can come at 8:30. Peter Swire here and Aaron Altschuler here will be respectively the moderator and the rapporteur of the workstream 1 on data. Yanis Karklins here and Wolfgang Schulz here will be respectively the moderator and rapporteur of the workstream 2 on content. And Martin Botterman here and Stefan van Gelder there will be respectively the moderator and rapporteur of Workstream 3 on domains. With that, I hope you will keep the same spirit. We'll work hard tomorrow not solve the problem, but at least have a common understanding of what are the subdivision and the manageable chunks to move things forward. And with that, I declare this session closed and release you into the atrium. And thank you again, really. Oh, that's cool. Thank you so much.
Thank you for letting me participate.
No, it's a great
I thought
pleasure.
my provocation was at the right level.
Yeah, yeah. No, that was absolutely, absolutely good. It's a typical example.
Oh, sure.
Yeah, I think it's super. Well done. Enjoy. I'll be around. Yeah.